Today we'll be talking about trials. And trials occur because a crime has been committed and someone has been accused of committing that crime. Arrest occurs, and the arrest is based upon, can be conducted two ways. One is with a warrant and one is without a warrant. And usually the arrest occurs based upon a witness's testimony. Someone saw a crime being committed. Police investigation, they heard about it and went and checked out something. And unfortunately, the suspect has run his mouth about something he's done to other people, and they might tell. After the crime is committed, the person is arrested, they're taken to jail. There, they go before a judge, and the judge is like a arraignment. They let them know what they're being charged with. They read the charges to them. After that time, they'll go back for another hearing, or preliminary hearing, and this is a probable cause hearing. There, the state must prove that the person who's been arrested more than likely committed the crime than someone else. After that particular time, if the judge finds there is enough evidence to hold this person accountable for the charge, they are bound over for what we call a circuit court hearing. They have another hearing, another arraignment. They're read the charges, and then they actually enter a plea. After that particular time, between the time they go to preliminary hearing and the time they go to trial, it could be months. It could even be years in some cases, depending upon court dockets, court dates, and things like that. If the person has the money, or their family have the money, they can get out on bond while they await trial. If not, they'll be inside the jail until the trial date comes up. One of the most important times doing this is the discovery phase. In discovery, what happens is that you're a lawyer, which everyone who's given a lawyer wants to be accused of a crime. Now, your family may have money, or you may have money. You can afford to hire your own attorney. But those who unfortunately do not have the money, counsel, a lawyer will be appointed. During the discovery stage, your lawyer requests the state to show them all the evidence they intend to use against you. Consequently, the prosecution or the state can ask your lawyer to show them all the things you plan to use in your defense, such as alibi witnesses, whether you're going to take the stand, things of that nature. After that particular time, you can go to trial. And there are two ways you can have trial. You have a trial by judge, and you have a trial by jury. A trial by judge is that the judge listens to all the evidence from the state and from you, or your loved one. They listen to both sides, then they make a decision based upon the facts and the law as they understand it. With a jury trial, the judge is like an arbitrator. He sits between the prosecutor and your lawyer, and he applies the law to whatever facts y'all put in. The jury makes a decision on the facts they hear, whether they think you are guilty or not guilty of the crime. There's another alternative to that. The alternative is that the person who's been charged makes a decision after consulting with their attorney, and they say, well, I don't want to go to trial. I'll plead guilty. Usually in situations like that, plea bargain agreements that you've heard about, the state usually agrees to reduce the charge and reduce the sentence for a plea of guilty. And after that time, the sentence is imposed after a few administrative things occur. If a person goes to trial and the jury finds him guilty, he'll have a matter of time, depending on what jurisdiction he's in, to file for a new trial or to get ready for an appeal. We'll be discussing appeal in our upcoming video. Now, in the trial situation, I wanted to highlight discovery because these are the things that's most important for you to prepare a defense in order to defend yourself when you go to trial. A lot of times people say, well, I had this witness and I want this done. And being up under the stress of being arrested, being in jail, you might not remember it all. And you may not have wrote it all down. And I'll tell you the importance of discovery now, and we'll bring it up again when we get to the after conviction stage of our videos. This is just a general overview of the arrest and trial procedures. Some situations may vary in different jurisdictions, but basically it's the same thing. You be arrested, you go to jail, you get the charges read, they found if it's probable cause exists, you're bound over for trial, you'll be appointed a lawyer if you can't afford one. The jury can hear your case, or you can have a case before the judge, and then a finding of guilt is made. Hopefully that this will give you a better idea of exactly what happened to your loved one when they did go to trial. Because the more we know, the more we'll be able to do for ourselves. For short of God's intervention, knowledge is our best defense against injustice.